So to start off, I'll start the subject. I'll have anything. So I don't have the textbook. Are both of yours the new ones? Accordingly, they've made changes to the textbook. That's it. Okay, so before I move into this whole subject, I'm just going to give you all some basics about what you all should. Not there in your textbook, it's not part of portions, but it's generally better that you all know these concepts before anything. Start off with this has mainly to do with the first chapter. I'm not starting into the chapter. I'm going to give you an introduction. So in the sources of law, you will technically be studying about two. First thing is about Indian laws. And the second half of this chapter is you will literally be studying about what is. So this is fully theory based, fully theory. And this goes into the full concept of where did laws come? When did we first start following? Like saying, why should I listen to you? Why should I listen to a rule made by, say, academy? And why should I follow a rule made by the government? So, what is a law and why should I follow? So, you have 5 groups of people who came out and then they gave their own definition. So, we'll be studying about that. But then, this Indian laws, this is where I'm going to be taking your introduction. So, in Indian laws, the first thing you all must know about is the 3 organs of our country. I won't say of our country, but the 3 organs we call it. They are known as the first one, the legislature, have the executive. You all heard these, studied it in political. I'm going to be giving you an introduction to this. Now, generally, if we have to look at the legislature, we'll say the legislature, the laws. The judiciary, we'll say, is interprets the. And executive implements the. Remember this, we'll go on to detail. We're first going to be going into the legislature. Okay. So, who exactly is this legislature? For that, you need to understand that we have a parliament, have state, so I told you that there's a national level and then there's a state level. So that means in our country, there are 2 powers. We have powers at the Union government, that is what we call at the national level. Then we have the state level. This is how power in our country is divided. So if you notice, like we have a Tamil Nadu government, but then we also have the government at the center. We have laws made by the Tamil Nadu Legislative Assembly, and we have laws made by the center. So does it mean that anyone is under the other? The answer is. For this, I'll be teaching you one concept known as federalism, but that will come later. In our country, it's unique that way. We have 2 sets of government. and it's interlinked with each other, the powers. So this legislature consists at the union level and at the state level. Now, in this parliament itself, you have someone known as Rajya Sabha, and you have the we won't go into state, okay? Not necessary. We do learn one topic under Lok Sabha, Rajya Sabha, so that's telling you all. So our legislature consists of Parliament, Lok Sabha, Rajya Sabha, and the state legislative assembly. And the concept is that both of them share power. It's not that the state is subject to the national power. It's not like the government in the center tells the state. There's some power that the say the BJP government has, and then there's separate powers that say each state government. This is how our country. Okay. Next, we have the judiciary. The judiciary is it's a slightly longer topic, and I'm going to go into much more detail. So, in the judiciary, generally you have Supreme Court at the center, located in, and there's only one Supreme. So, in other words, they live in call it the apex court. That means the topmost court. Then under the Supreme Court, you have the High Court. But then you have one High Court for each. So let's say we have one in Tamil Nadu. Then we can have one High Court in, say, Karnataka. We can have one in Assam. Basically, one High Court in each state. Then under the respective High Court, we'll have the lower court. Okay. Now, these lower courts also, you can divide them into civil and this is a very general outlook of how the courts are divided in our country. So, if you look at it, what the Supreme Court says is binding on all the lower courts. So, what do I mean by that? If you look at Article 141 of it says one line simply. The law stated by the Supreme Court is the law of the land. That means any decision given by the Supreme Court has to be followed by all the courts. That's why I drew this arrow downward. Now, the same way, if Karnataka High Court gives a decision, all the courts below Karnataka High Court will have to follow the decision of this particular court. If Tamil Nadu High Court gave the decision, all these courts will have to follow that decision. But generally, if the Supreme Court gives a decision, every court has to follow it. So this is how, like, a law made by, say, the judiciary follows downward. So always remember, power flows downward. But whenever you are starting a case, you're instituting a case, you have to start at the lowest court and then only go to the highest. So let's say you have a dispute. Let's say you bought that panel, okay, LED panel, and you have a problem with it. You decide to go to court. Let's assume for now you don't go to this court, but let's assume you're going to a civil court over here. First, you have to go to the civil court. It's not a criminal court, so it's not a criminal case, so you don't end up going to that. First, you go here. Then you can go and appeal to the High Court. Then you go and appeal to the Supreme Court. I'll explain concepts of appeal and all of that later, okay? But I'm just giving you an idea of how power flows down. But when we are starting a case, we have to start from the bottom and then go to the top. That means you cannot go directly to the High Court. Similarly, you cannot go directly to. This is how courts function. Now, one thing you need to understand over here is that I very clearly told over here that legislature makes or they interpret the law. Now, what happens is that the legislature, they sit in parliament and then there's a process that they follow and then they pass this particular law. Now, what law is the judiciary interpret? They're only interpreting the law. They're only interpreting the law made by the legislature. Similarly, the executive is only implementing the law made by the legislature. So this is one rule that we'll eventually talk about later, but it's like saying, okay, the legislature has passed a law related to Hindu custom, how Hindus get married or how divorce for Hindus happen. Have a law. Now, the judiciary, their only role is to interpret law made by the legislature. They can't interpret any law that is not made. Okay, so, if the legislature did not pass a law, then they can't give an interpretation of it. Now, why have they been given these particular roles? Very simple. You notice they're sitting in parliament. Who are they? You know, our MPs, our MLAs. Are they people who are very good at science or politics? They're great at, but do they know about science or do they know about urban planning or do they know about the subject matter on the topics? I mean, the laws that they're making. Are they experts on it? No, right? They're getting a report from someone and then they're making the law. But finally, it is the judges who are coming in contact with the people every day. So let's take, for example, there is a law related education. Now, this law has been passed, and it said that if a student is not allowed to write their board exam, then that university will be punished. And let's say you were prevented from writing your 12th board. The school basically said, nothing doing, you didn't get so much marks, so we won't let you write. Now, you have a problem with the university, correct? Where will you go? To go to a court only. Now, but who made the law? Legislature made the law. But are they sitting in front of you as the judge? Judiciary who sits. So what the judiciary does is they are like the middlemen between you and the legislature. And what are they doing over here? They're hearing your side and then they'll hear your school side also. And then they take this law and then they'll apply it to your case. So these are the people coming in contact with y'all, with people daily, the different kinds of cases that are coming before them. They're the ones applying the law before them. This is the role of the judiciary. Now, in this process, they'll end up creating a type of law, which we'll go into detail later. And then finally, you have the executive. Now, let's say Parliament makes a law. They pass the law, but how do we follow it? What if we choose not to follow it? Then what will happen? So, in 2019, the government passed that Citizenship Amendment Act. That the riots and all happened before COVID. Where were you? The riots were the first time CS even cancelled their exam. Okay, since you are not aware of it, I won't. But let's take, for example, recently they've passed, say, an amendment to some law. They just passed a law. But we, the people, are very unhappy with that law. So we are like, fuck it, we won't follow it. Do that, no. That choice, right? Then what will happen? Okay, take for example your criminal. Says that if you hit a person on the highway, will be held. You're driving really fast, no, you end up hitting a person. Now that person died or is in the hospital, something. What happens to you? By whom? Judiciary. No, I'm talking much more practical. Who is the first person who will land up over there? Or someone will take you to the police station, right? And file an FIR against. Who's that police? Are they the are they come under the executive? These guys, they take the law made by the legislature and they implement them. So if you hit someone on the road, or if you were caught committing some crime or some offense, the police only come right first, or some person to implement this law. So all your IAS, IPS, your IFS services, your administrative section is all your government generally. So if you take GST for example, your GST office comes under executive. These are the people helping to implement the law. So now are you all clear with legislative, executive? Okay. Now, if you look at like where, uh, if you ask me, ma'am, where can I read up more about the executive or legislature, you won't really find a topic that's or a law that says, okay, we have a legislature and this is their role. We have a judiciary and this is their role. Rather, this is assumed from our constitution. So all these powers come from our constitution. So I am going to go into a little detail about constitution. Okay. What do you all know about the constitution? Or your general knowledge? I thought you all could forget it. It's part of your syllabus. What do you all know about the constitution? What is it? First and foremost, it's a book. Clear book. And if you look at this constitution, drafted in 49 in November. And finally, in Jan, it came into existence. Much you all remember? So, like I said, it is a book. Fine. To explain why the constitution is so important, you must understand. We have the president, we have the prime minister, we have the vice president, have like the whole set of a full government as such as you call it, right? Now, can we say that the president is more powerful than the prime minister? Or can we say that the prime minister is more powerful than the vice president? Or can I say that the Constitution of India is more powerful than the answer is? We have created our law in such a way that nobody is above the law. And what is that law? Constitution. So, literally, the Constitution was brought in place so that no one person is more powerful than, and that we have all these positions and posts, etc., keep each other in. So, we have like the president, prime minister, vice president, all of them are the executive. Then, like I said, you'll have your judiciary and your legislature. So, your Constitution of India, I will say, is your most important document, not just as studying law, generally in this country. Now, why do I say that? Is because so only if the Constitution gives permission, you can do that action. Now, best example I'm going to give you is the coming in of. Okay. Now, I'm going to tell you a little bit about pre-GST and post-GST. what happened was in pre-GST, the law simply stated that the center, that is the national government, currently it's BJP, the BJP could impose some laws, and then respective state governments could impose certain others, or taxes. So essentially, you were paying two taxes, one to the central government, one to the state government. And the laws were made in such a way that it was a full confusion only. You were paying double the duty simply because you're paying one to the central government and one to the state. Now, post GST, what they wanted was they wanted to do away with all of this. And they decided to make it a one nation, one tax. One tax. That means you're paying only one tax, and then accordingly it will get spread to your central state, all of that. But for this, what they had to do is they had one huge problem, that was because the constitution only allowed for this. To bring in GST, we had no provision in the constitution that allowed for. So what we had to do is we had to go ahead and amend the constitution. Now you may ask, why do we need to amend the constitution? To bring in GST, let's just bring it in, right? The answer is not so simple. Why? Because this constitution is the most powerful document in this entire country. Unless authority comes from the constitution, that thing is not allowed. So because if we didn't amend the constitution, we couldn't have brought in GST. So what they did is they went ahead and amended a lot of articles in the constitution to finally give way to GST. That's how important your constitution is. Okay, so generally itself, if you look at the constitution, it gives power to your legislature, gives power to your judiciary, and to your. This is the power of your constitution. And then accordingly, each person is given their respective duties, and then you carry forward. So this, I'll stop here now for constitution. When we're coming to the chapter, I'll go into much more. But let's go through again. Starting, this is all for sources of law. Chapter number 1, I was discussing your Indian. So in Indian laws, you need to remember that we have the legislature, the executive, and all of them come under the Constitution of India. Legislature, laws, interprets laws. So we're going to be mainly looking at these organs, legislature. These are the ones we'll mostly be looking at. Mainly, it's judiciary. We have one chapter that is wholly dedicated only to these. Chapter number. Now, in your legislature, we have powers at two levels, one at the national level and one at the state. This is what we call a quasi-federal. Again, I'll explain this in detail later. So that at the national level, we have the parliament. Level, we have the state legislative assembly. So for parliament, it's required for you all to remember this. And we have the Rajya Sabha. State legislative assembly, we don't really study in detail. It's not required to know. What do? They interpret the law. Remember, these people are like middlemen. Middlemen between the legislature and I'm just going to write common person. So when there's a dispute, you go before the courts only. So how do you approach the courts? They're largely divided between civil and criminal. So if your matter is a civil matter, you'll go to a court. you go to a criminal. Then, if you are unhappy with the decision given by the lower court, you can go on appeal. You go directly on appeal to the Supreme Court. You go to your respective high court. Now, let's say you've gone to the high court in Tamil Nadu and you're unhappy with that decision also. Then you can go on appeal to the Supreme Court. So I had drawn go like this. But this Article 141, which I'll explain later, states that the decision given by the Supreme Court has to be compulsorily followed by the lower court. Now, I will explain later what do you mean by following a decision of the court. But simply, this is something that you all must just have it printed in your mind. If the Supreme Court gives a decision, follow it compulsory. If a high court of, say, Karnataka gave the decision, all the courts below it need to follow the decision. If Karnataka High Court gave the decision, these lower courts don't, at least not in the strict. And then what if, like let's say in your lower courts itself, there are lots of courts. So the higher the court, follow it like. But generally they'll say Supreme Court gives a decision, everyone follows. High Court gives the decision, everyone follows. But just because a civil court gave a decision doesn't mean a court lower to it needs to follow it. It doesn't work that way. So remember these two. To move from bottom to up, power moves from top to bottom. And executive, we'll study after we finished concepts. So you're clear with these concepts? That would take a 5-minute. I'll start off with the chapter. Be here by 5:10. So we're starting with chapter 1. This chapter alone, only this chapter, don't follow your text. I'll be sending out notes. I'll follow that. It's more. They've managed to confuse me. The second part, this they fully confused. Then I had to go find out like the actual thing, and then I created notes that way. And like I said, the minimum 4 marks. They've never asked 8 marks also from the chapter. Let's say expected, they can ask even 8, but they ask only one question. So please remember, if you want, you can go through the textbook, it's fine. But if you get confused, don't worry, just follow my notes. So I'll be starting with this concept of India. This entire chapter is divided into these two. Under sources of Indian law, you have primary, you have so we have and under this we have 5 schools. This sources of Indian law, we have primary and of Indian sources of Indian law. I'll try covering that today. Finish great, if not, this class. The schools of thought only go into what is law, why should we follow law, and we'll be studying about 5 different, call it schools of thought. That means the different definitions that people can, we'll be studying about. Let's start with the first one. Guys, I'd like you all to before I start, I'll just tell you how they've given. Chapter number 1 started with this introduction, which actually relates to the schools of thought. That's the part 2. They've given one introduction, these 5 schools, and that's what they, like I said, they've given some definition the same. And as you go down, they've suddenly moved on to the next topic, that is sources of India. And then they've given in, after finishing this topic, they've gone back into school. So in your textbook, they've actually confused it up a little bit. But I am going to be starting from this sources of Indian law. Start with this. So in sources of Indian law also, we have guys, please take notes wherever possible. Textbook, they've given these four only, but in a little different order. They've given customs first, then I think statute, that order. But I'm going to ask you all to follow my own. Be easier for you all to remember. Take it down so that you'll have practice. One is statute, a judicial precedent. R is not precedent like president. Customs, and we have personal. Secondary have and good conscience. Sources of English law has a further classification, but I'll come to it when. So first we're going to be starting with this statutes and legislation. See these four words that I've written: statutes, legislation, law, act. All mean the same. That is, they're all just synonyms for a law. But a law made by whom? A law made by so simple way to remember this is you all know the word legislature. Legislature makes a legislation. Legislature we also call a statute or law. Now, what is this act? Okay, we have the Companies Act. If you look at it, we have Indian Contract Act of. So that's why we're using the word act. So if I generally say this act says so, I'm right. That's all. Now, these statutes and legislation have a further classification. So you just need to understand the concept between. In statutes and legislation, we have something known as supreme legislation. We have something known as a delegated legislation. The word supreme means topmost, like the highest authority. The word delegation means I'm telling someone else to do that work on behalf of me. So let's say, for example, today I tell Gayatri, prepare for this topic, come tomorrow and teach them. I'm not going to be here. I'm delegating my job to her. That is what delegated means. Now, what is the supreme legislation and delegated? If you look at supreme legislation, it's stating this is the definition of it. Okay, I'll explain more. If it gets its power directly from the Constitution. Delegated authority. delegated legislation, that it does not get its power take this down and then I'll explain. So, what do you mean by this? Get its power directly from the Constitution. So, if we have to generally look at it now, have, let's say, Constitution of India. Now, I said, right, the Constitution is the highest law. So, if you see the articles of the Constitution, it gives power to someone known as the president. It gives it gives power to the vice president. It gives power to the, say, prime minister and cabinet. It gives the power for appointing governors. Okay, similarly, the powers of the judiciary, and everything is coming mainly from the. So, if you look at it, the any law made by Parliament or state legislative assembly, it's coming directly from the Constitution. The power to make laws is given by the Constitution to the legislature. So, any law made by Parliament will be supreme legislature. Now, you may ask, ma'am, so that means state legislative assemblies are not supreme legislature. What? The answer is no. They are also supreme legislature. Why? The Constitution gives power to the state legislative assembly also to make laws. So, any law made by Parliament or state legislative assembly is a supreme legislature. Then what is delegated? I told you it's the exact opposite. So, what happens in our country? Let's say, for example, we need to take a survey in our country. Now, the government of India decides, okay, we're going to pass the new law for the purpose of survey. It'll include like Aadhaar and like a bunch of things. But the center, that is at the national level, they're going to pass something known as the Survey Act. This is all example only. Okay? And they decided to pass this law. How are they going to take the survey? They need to appoint officers, people, departments. So one huge, like they're going to have to appoint so many people just to take a national survey. But most importantly, the government knows, if I pass the law, how do I know each respective state government will implement it? So what they'll do is, they'll delegate this to the. Now you may ask, I just told you right now that state legislature is the supreme authority. Why then am I saying this state authority? There's a very simple criteria for this. In our constitution, we've given some subjects, like let's say nuclear, defense, arms and ammunition. One set of lists we've given only to the center to make law. This the state cannot touch. But then say some other topics related to land revenue, stamp duty, etc. we've given to the state governments. That only the state governments can make law. Again, I'll go into much more detail with these topics later. So that time when they are making laws on their respective subject matter, then it's supreme legislature. But let's say this topic comes directly under the center's power to make law. That means what? The state actually cannot make law on it. But because the whole activity is so large, we need all the states to come together and implement it together. The center is delegating this to the. So it's saying that, okay, each state can make, say, Tamil Nadu survey act, Karnataka survey. You'll make your own laws, and then I just want the survey done within the next 2 years. So what is the center doing over here? It's delegating its authority to the state. Now the same way, multiple examples is the state can delegate the power to the municipal corporation, just passing on power to the next person. Like, let's say for right now, when Dimsha came and said, "You talk to academy," she's delegating her power to me, right? It's not my duty, her duty, but she's telling me to do it. That is delegation. So we'll come across many more examples as we're studying this particular topic. But for now, have you understood this? So this is only your supreme and delegated legislature. Now, one more criteria that you'll need to know under supreme delegate. You need to know something known as just are like Latin words. You'll come across many such words like this. Just scriptum simply means written law. And just non-scriptum means unwritten. Other words, just scriptum is basically your law made by whereas your just non-scriptum is only your custom. Criteria actually is in your statutes and legislation, you have a scriptum and you have under just scriptum, you have team legislation, have delegated, and under just non-scriptum, one thing you need to know is legislation and delegated. There is more to this, but I'm not going to do it immediately because I'll still need to understand a few more steps to make sense of these and delegate. So far clear with this? Next one we're going to go on to. The next most important topic is actually judicial. Start with that. One more thing you'll need to. Okay, I've made that. New term you are going to be studying, not President of India, President. This is basically law made by the judiciary. I asked, ma'am, how do the judiciary make laws? Because you specifically said that legislature only makes the laws. It is only supposed to interpret the law, right? We're going to understand what exactly I mean by this. So let's take, for example, we have your Company Act. thousand. This is an example. You all will study later about it, but Section 164 Clause 2 stated one thing. You don't have to write this. Follow my Section 164 Clause. Okay, Companies Act states that every company must have a memorandum of association of the terms that you all are aware of. So, in this MOA and AO, or more specifically, it says for a public company that there must be 7 subscribers. Additionally, another section also states that within 6 months, like, okay, let's say one company XYZ Limited and has 9 promoters. Another name for promoters is basic subscribers to the memorandum. Now, what happens is during COVID, close to 4 directors are. So, how many are you left with? 5. You need a minimum of 7 to make up for it. Now, the law states that within 6 months, they must add this remaining 2 directors to make up for this 7. But these people died due to COVID. And because of the lockdown and some reason or other, they were unable to appoint 2 more directors within the 6 months. And now what has happened is the registrar ROC has sent a notice to XYZ. You don't have the requisite number of directors, so they're looking to find this company. Let's just assume that these are the facts. I'm not going into the detail, but I'm going to explain to you how judicial. Now, what has happened is, what is this? It is a law made by legislature. It is a law made by legislature. But when ROC sent the notice to XYZ Limited, can you see what problem has come up over here? They weren't able to appoint those 2 directors because of COVID. If COVID was not in the scene, then the company is only wrong, right? Then there's nothing you can do about it. But here, XYZ Limited believes they have a valid reason. So what they do is they decide to court. Now, which court do they go to? Here, the court for this matter is NCLT. So before the NCLT, you have 2 parties. You have XYZ Limited and ROC. So now NCLT, what they look at is they look at the facts of the law, evidence, all of that they'll put it. And then finally they give their decision. Okay. Now, this is only an example, okay? Please don't take these quotes, etc. as thing. I'm only giving you an example to help you understand. Now, according to this concept of precedent, a decision given by the court itself is a law. Actually, a law is law made by the legislature. But then NCLT, after looking at the facts, the evidence, the whole judgment, hearing both the sides, etc., they've come to a decision. And this decision, what it says is, normally we wouldn't have allowed for it, but because of COVID, this court now allows XYZ Limited another 3 more months to appoint the remaining 2 directors. So this is going completely against the Companies Act, right? Companies Act is only giving 6 months, not any more time. But then the court is going ahead and increasing it by 3 months. So this is a new interpretation in law, right? That by itself becomes law. So I'm going to take off this example for now because actually if an NCLT gives decision, it doesn't amount to. So did you all understand the concept though? if we keep this in mind, what happens is every day, daily basis, we have so many matters being heard before the high courts, the Supreme Courts, the lower courts, everyone. Now, this judicial precedent can only be given maybe by a Supreme Court or a High Court. So now I'm going to bring you back to this. The highest court is Supreme Court, then you have High Court, and then you have the lower court. Amongst the lower courts, you have civil. Just remember this. This should be like pasted in your head. Now, what happens? What is this judicial precedent? Now, remember, I also said that if the Supreme Court gives a decision, it's on all the courts beneath it. The High Court gives a decision, it's binding on all the courts beneath it. This is only a. So, to simply put it in words, I can say that a precedent is given by a court after looking at the facts, the arguments made by both parties, and then only they're finally coming to a decision. So I can say that this decision is based on merit. Merits meaning they've taken the facts, they've taken evidence of both sides, arguments of both sides, and then finally they've come to one decision. And obviously they've considered the law which is applicable. So if a Supreme Court does this, like let's say the Supreme Court gives this decision is judicial. If a High Court gives a decision, that is known as a judicial. And this judicial precedent has to be followed by the lower court. Now, I've given a very simple criteria over here. It's actually a little more detailed. So we go into that. At the top, you have but when I said that you have one court, it doesn't mean there's only one judge sitting over. You'll have multiple courtrooms in the Supreme Court. So let's say a single judge is known as a single judge bench. If you have two judges, it is known as a. Please keep this also in single judge bench, division bench, and then 3 judge becomes 3 judge, 5, 7, 9, 11. The highest number of judges we've ever had sitting in court gone up to 13. This was for one very famous case. 13 judges sat. So only for you have single, only in division bench there'll be 2. But after that, it's always in odd number. 3, 5, 7, 9, etc. So in the Supreme Court itself, you can have so many. Now, it's not like, oh, this court means there'll be 3 judges. This means there'll be 13. He'll decide upon each case. I won't go into detail. Now, when a 3-judge bench gives a decision, binding on the division and you'll understood this. In the Supreme Court, have 3-judge bench rather than a division. A single. That means in the Supreme Court itself, if a 3-judge bench gives a decision, a division bench and a single bench has to follow that decision. Whereas, if a single judge bench gives a decision, a 3-judge bench can overturn it. They can completely change up the decision. It's like how we go from lower court to high court, go on appeal. If the lower court gives a decision, the high court can give a completely different. The same way, if a single judge bench gives one particular, the 3-judge bench can completely overturn it. This is how it works. Then you have the High Court. In High Court also you can have 3 division, and then you have your lower courts, which is, so now you're understanding the criteria. So whenever we look at case laws, we'll first see which court has given the decision. Is it High Court? Okay. If it's High Court, then we'll try finding a Supreme Court, because we'll have to follow Supreme Court decision. Now, if Supreme Court has given it, how many judges have given that decision? Is it 3, 5, is it 7, or a single? We look at all these criteria to simply determine what is binding. Now, for example, I have a decision by the High Court, a High Court of Karnataka. And this High Court has specifically said, if the number of directors go below 7, that company is punished. But then the Supreme Court came out and said that because of COVID, it was a huge shock for the entire country. So therefore, we will give an additional. Now, which decision will you follow? Obviously, Supreme Court. Now, what if the Supreme Court didn't give this decision, and instead another High Court, but this time in now 2 questions come up. One, can the High Court of Assam give a decision like this? This court already said 7 directors. If it comes below, we're going to punish you. If you don't do it within 6 months, we'll punish you. Very clear. But then the High Court of Assam has now come up and said a completely different thing. Is it the Supreme Court? It's a High Court. Have the same powers. One is in Karnataka, one is in Assam. And now Assam High Court has said, okay, we'll give you 3 years. Why? Because COVID. First question, are they allowed to do? What do you all think? They are allowed to do it, because they are high courts only. They essentially have the same power. Now, if I have these 2 decisions, which one do I follow? By the way, I'm located in Tamil Nadu, and I'm arguing before, say, the High Court of Tamil Nadu. Let's say I'm the party, I'm the company. So obviously, I want an extension of 3 months. So I'll be moving towards the High Court of Assam. But then the ROC will be like, the ROC is only against me. No? They only want to punish me. They'll want to go with this decision. So there's a conflict here. What do we do? The answer is very simple. Neither of them are binding on me, but merely has a persuasion. That means before my High Court, I'll go and tell the High Court, Your Honor, in Assam High Court, the judges gave so. Please give a decision similar to this. ROC will go and make the exact same argument for the same. They'll be like, Karnataka High Court gave this decision. Please implement this accordingly. Now it's up to the judge to give his. That means he can take either this decision or he can take. Like you all coming in asking me, when you all start writing tests, like ma'am, it's exactly like that. You're just asking the judge to do something. It is not compulsory for the judge to follow that decision or this decision. So based on this concept, I will be explaining the types of precedent. First one, you have original precedent. An original precedent is a court, a new interpretation in a court gives a new interpretation of law. The second one is declaration. I'll finish telling you what each one is and then I'll declaratory precedent. A court only declaring, but here distinct position. One, when a court gives a new interpretation, or it is original. When a court is merely declaring an existing position in law, means declaring an original. I'll explain what it is, but this is only declaratory. Third one you have is persuasive. Persuasive precedence is um, precedent is not in as value. Fourth one is absolute authority. Take these down. Where so for absolute authoritative, I've written a decision given by a higher court. Understand, it's not high court, just a higher court is binding on the lower court. Here, conditionally authoritative precedents, decision given by the higher court is not binding due to reasons of law or take of law. Write it down. Now put your pens down and just going to be giving you all examples of how this is working. Let's say in 2018, we are now before the of India. Now the Supreme Court is hearing a matter on. Actually, let's not keep this 2008. Just 2000. Do you know about cryptocurrency? Coin. You'll have heard of the coin. So they're hearing about some matter related to crypto. The problem with crypto is there is no law for it. No law. It's a new concept itself. Even the courts don't have anything to go ahead with. But some matter has come before them, so now they're hearing this matter. They've come to one decision where the Supreme Court has come to one particular. The decision could be something like, say, crypto exchanges have to comply with before they take on new people and create accounts. This is one decision given by the Supreme Court. This becomes a precedent. The new interpretation in law. For the first time, the court is coming out and giving some clarity on something. There was no law, but even if there is a law, sometimes it can be. It'll be for various reasons. Like let's say in one law, they'll say that 18% tax on. But now you have a tomato window. This guy is like, is it a fruit or a vegetable? And the thing is, for fruits, right? For fruits, it's only 5%. What do you think he's going to go with? Fruit is not vegetable or, tomato is not fruit or vegetable. So like one genius, he's paying 5%. Now, GST department is coming behind. Can't you clearly see 18% tax on vegetable? Now, this tomato trader is like, what to do? Tomato is a fruit. So now it's a revenue loss, no, to GST department. So he'll take him to court. Now here the court will analyze the facts and then the court will come up with one decision. Yes, tomato is a vegetable. And till now he was paying 5% tax, pay up 80%. Court can give this decision. This becomes a original precedent. Now, court gave this decision. Now it's found out in the year 2020. You've been following crypto news? Very recently, like the last few, one of the biggest crypto exchanges crashed. Just crashed. One huge scam behind one of the owners of this exchange, and it just shed a lot of light as what was really going behind. Now in 2022, you've got Gayatri. In the interest of all the crypto holders in our country, he takes the matter to the Supreme Court, okay, and against all the crypto exchanges. He can do this. It's public interest. I'm not going into that detail, but she's gone and she's filed suits against all these crypto exchanges. Why? He claims before the Supreme Court that the crypto exchanges are not following, they are unregulated. She's just going on one rant over there. Basically, for the reason that she wants to protect all the crypto holders in our country. And somewhere in between the argument comes up that the crypto exchanges are not being regulated, they're not coming under banking system. Now here the Supreme Court is telling Gayatri, listen buddy, in 2014 the Supreme Court already spoke about this. That what Supreme Court only knows. While this may have been a 3-judge bench, it's also a 3-judge. And they're saying, we've already discussed this in the past. No point bringing it up again. Been one decision over here, but they would have considered all the factors before coming to this point. So the Supreme Court is merely repeating the same decision even in this manner. So what is happening over here? They're merely declaring the precedent. Saying we already laid down guidelines them. There's nothing more that we can say. And these guidelines, whether they have been followed by the crypto exchanges, maybe they have been followed. They are taking up KYC. And we can't give anything more on this particular topic. So they're merely just applying the exact same decision. This is only known as declaratory precedent. I'll give one more example for this. Okay, this same 18% tax on vegetables. Finally, what did the court say? Let's assume the Supreme Court gave this decision in 2000. What is the decision they gave? They said that tomato is of the vegetable and liable to tax. Now they didn't just say this one line. They said that in future there might be few more confusions coming up as to what is a fruit and what is a vegetable. Like take for example a cucumber or something. Scientifically we can say it's a fruit. So they gave a criteria. They were like, okay, if these vegetables fall under this criteria or these supposed fruits fall under this criteria, they will be taxed at 18%. Even though scientifically it's a fruit. This is what the court says. Why? Because GST has to collect their tax, right? The Supreme Court gave out a very detailed judgment to how to classify between fruits and vegetables. Now fast forward to the year 2022. We have a cucumber trader. This fellow is also trying to evade tax. And let's say he was cucumber, that's what, he was paying only 5% tax because he assumed it was a fruit. Now when he comes back to the court, when it's being brought before the court won't even look at anything. They'll just apply this decision. Why? Because it's given by Supreme Court. Supreme Court is binding on all the other courts. So here the cucumber trader will have to pay up 18% tax. What are they doing over here? This 2018, it was an original precedent. They're creating a new interpretation for the first time. Whereas in 2022, they're like nothing doing. We already discussed this 4 years ago. I'm applying the same decision. This is known as your declaratory precedent. I'm going to change up the facts a little bit. Now, here, let's say in court, but here, Supreme Court 5-judge bench. Here it was a judge bench. You see, a 5-judge bench gave the decision. Then only 3 judges. They have to follow the decision of the higher court. They don't have a choice. But what if this became a 7-judge? Now, is it compulsory for them to follow the decision of this court? The answer is no. They can change it up if they, but they believe, no, this was a very valid decision. We're going to follow the same. That also they can simply. In this situation, the scenario is simply that it's no longer compulsory. If they so want, they can say nothing doing this decision. Add one, they can change it. Now, again, I'm changing up the judges. let's say over here, decision was given by the High Court of Gujarat. This decision, let's say in this decision, what happens is cucumber trader, he is before the High Court of Telangana. And the Telangana High Court is like, you know what? Cucumber, it's only a High Court Gujarat. They are stating that cucumber is a fruit and therefore the 5% tax is High Court. They can give varying decision. Now comes, I'm before the High Court of Tamil Nadu. I want 5% tax. GST department wants me to pay 80. So what I do is, when I'm arguing before this court, I try taking this decision as a precedent. I'm like, the Telangana High Court in the year 2020 held that cucumber is a fruit. So therefore, 5%. Whereas GST department will come out and choose the Gujarat High Court decision. Right. Now, what will the Tamil Nadu High Court do? The thing is, when it's related to high courts, it is only persuasive value. Means that the court can neither listen to Telangana High Court or Gujarat High Court. They can give their own decision, or they can choose to go with any one of these. It's what we call as persuasive value. Persuasive means it's not compulsory. Say a Supreme Court gave the decision means it is compulsory. Are you following this, like how precedents work? So it matters also which year it was given. Like let's say a Supreme Court gave a decision in 2018. Then it's in the year 2020. I will have to follow the decision in 2008. But in contrast, say in 2022, they went ahead and changed the whole. Then today, what they gave as a original declaration will be my future case. In future, someone comes for the same point in law, they'll have to follow today's judgment. Okay. This is how precedent, apart from the law made by the legislature itself, have laws that are made this a decision. And it is applied on the basis of original declaration persuasive. Now, two more we'd studied, right? Absolutely authoritative and conditionally authoritative. All precedents follow this rule. It is absolutely authoritative, which means if a higher court gives the decision, the lower court must follow it. There's no choice. They can't be like, oh no, but I feel like it should be different, so I'll apply different. Nothing doing. You have to follow as it is, unless there was an error or mistake in law. In that case alone, the decision of the higher court is not binding on the lower court. So these are your 5 types of precedent: original, declaratory, persuasive, absolutely authoritative, authoritative. You're clear with these points? You know, doctrine of fair, this is a Latin word, And under this, I'm going to teach you two terms, that is decidendi say it after me. Doctrine of stare decisis, ratio decidendi, obiter dicta. In short, I'll keep saying ratio or obiter. Must understand it's. So what is this doctrine of stare decisis? And I've written follow the doctrine of stare decisis, saying that do not unsettle matters that have already been. This is so what it's saying is do not unsettle matters which have already been settled. I've already told you. The Supreme Court gives a decision. We're saying that it's binding on all the same thing. If High Court gives, binding on all the courts below. But what if we didn't have this? Imagine how many problems would come up. Each person will keep going to different courts just to get a decision that is favorable. Like take for example the tomato trade. One court is saying that okay, you have to pay 18%. Another court is saying you have to pay only 5%. That means I'll keep going to different courts, no? And then I'll go with the court that puts only 5% tax on me. So to prevent this thing from happening, this is a form of uniformity in like okay, the Supreme Court gives a decision, everyone follow it. No questions asked. High Court gives a decision, follow it. Okay, we'll give few more rules. If a court with a lower number of judges gives a decision, then a higher number of judges can turn it around. So these are the rules that they are creating. That is only the doctrine of stare decisis. Follow it as it is. Don't unsettle things simply. Only if there's a valid reason to unsettle. Like, unsettle means change the decision. If you want to change the decision, make sure it's a valid. It's for a valid reason. That is the doctrine of stare decisis. This ratio decidendi and obiter dicta, what are they? If you saw, I wrote here, no? When courts give a decision, see the facts of evidence submitted, the arguments of both the parties, then they'll also look at the laws involved. What is the law saying on? That is law made by legislature. Then they'll hear both the sides and then they'll give decision based on it. Now, this particular decision, where the court has heard the facts, arguments, evidence, laws, etc., and then given a decision based on this, that only I'll call as decidendi. Stay with me. Obiter dicta is, I will say, the personal opinion of the judge. Now, come back away. You see here, absolutely authoritative precedent. Means, if Supreme Court gave the decision, the lower court has to follow it. Regardless of the judges, if the judge believes otherwise also, they still have to follow it as precedent. No choice is given to them. Unless, of course, there's a mistake of law. Now, just stay. What happened? This is an actual case. In Rajasthan court, there was one matter that went before the court. And the matter had to do with violence against women at the workplace. There was no law governing it. There was nothing women could also do. Now we have like vigilance, we have like a whole bunch of things. But at that time, we didn't have anything. And what happened was the Rajasthan High Court, in that particular case, they gave in their decision itself, they said, okay, here are the guidelines for prevention of violence against women in the workplace. And they gave like 1, 2, 3, 4, 5, 6 guidelines. This was actually the personal opinion. He believed that only if we have these kind of guidelines, can there be any change in society? Then, okay, this is not the best example to give, the facts of this. I'll give you all a different example. XYZ Limited as is required to pay, say, 20 crores. They're supposed to spend 20 crores. Let's say this is part of their 2% turnover, all of that. Now, what XYZ Limited did is they only spent 10 crores. And then they said that no, the remaining 10 crores is like it's going for ongoing projects. But it has been later on found out that this the remaining 10 crores, right, has been given to a fund started by the Prime Minister. Let's just assume these are the facts of the case. Now, over here, let's say the PM Cares Fund. Now, CSR rules say one thing. They recently amended this law saying that if you're donating to the PM Cares Fund, it's equivalent to spending for. Our law actually states this. They were supposed to pay 20 crores. They spent 10 and the remaining 10 they sent to PM Cares. But when did this PM Cares Fund start up? During COVID. And what happened was they just made a transaction into PM Cares without really having any formal note of it. Their books of accounts. Now, it sounds all very valid. Okay. But over here, what the judge personally believes is that no, there's some fraud. This personal belief. Now, all of this is evidence. They've shown proper paperwork, books, everything they've showed. Like, oh, okay, fine, it's gone into PM. But there's one personal opinion of the judge. No, he believes, no, I feel like fraud has been committed. The company has actually diverted 10 crores to some other matter. Now, this personal opinion is obiter. Now, where will you find this ratio decidendi in obiter dicta? At the end of every decision, the court will give one judgment. Now, in the copy of the judgment, within the words, you will find both of these. There won't be a separate topic that says, oh, ratio of the case and then like the points, and then obiter dicta and then the points. We have to find out within the wordings of this. So, how can you make out? The judge will literally lay out, this is the law, this is the argument presented, this is the evidence given by this party, and it is my conclusion that so and so is the decision. That is the ratio decidendi. But then in one other line, he will say, I personally feel that it is fraud that has been committed. That is only obiter dicta. So judgment can only consider ratio decidendi, or it can also consist of both ratio as well as obiter. It really just depends on judge to judge. What are we going to do with these two? Only the ratio to be carried forward as only this. This does not. What do I mean by that? Let's say decision given in 2018. The judge gave both the ratio as well as the obiter. Now we are in the year 2022. this decision is applying as a precedent in my matter. Only the ratio will apply in 2020. This arbiter has a persuasive value. That means what? In 2022, when I go before the judge, I can say, Your Honor, in 2018, the judge gave so-and-so decision. It was his personal matter. Kindly consider implementing the personal matter as a decision in my case. The judge can choose to ignore it or he can actually implement. That's what persuasive means. The choice of the judge. But this ratio is what carries forward as precedent. So this full precedence note, like original, declaration, whatever it follows the doctrine of stare decisis. Follow what has been by the higher court. What should you follow? Ratio as well as the arbiter? No, only the ratio. What is ratio? It is the decision given by the judge after hearing the facts, the evidence, the arguments, the laws. And then when he comes to his, that is considered as ratio. Whereas if he simply gives his personal opinion, that only has persuasive value and is not carried forward as precedent. If you all want to write it down, you all can write it down, but it's there in the notes also that I've given. So it's up. Not clear with. Why is it again? Customs are damn simple. The concept of it is extremely understand. Remember in like what's part I taught you the difference between scriptum law made by Parliament, just non-scriptum, which is unwritten law, custom. Okay, so what does custom mean? It is basically anything other than law made by Parliament. Okay, so how our country has I'll take you back through a little bit of political. Is that at first, like say before 1949, we weren't one country. We weren't just one landmass. We were a group of kingdoms that came together to become the Union of. So imagine each kingdom has their own regulation laws. So essentially, we did away with most of them. And then we were like, okay, we are now known as Bharat or India, and we are going to follow the laws made by the center or the state. This is what happened after independence. But obviously, each state had their own custom. Like take, for example, in Punjab. In Punjab and Haryana, you'll notice that the Sikh people wear the turbans. They wear their turbans. And okay, now think about it. When you all have two-wheelers, what happens if you're caught without? Fine, no. Now the same thing if you were a Sikh person wearing a turban. Can you wear a helmet over the turban? Answer was. So now it became a problem. The Sikh people are not going to remove their turbans while driving. And more importantly, they're not going to wear a helmet over. But then finally, like what happened was the government came to a sort of understanding saying that the turban also protects your head if you fall down. So you guys don't have to wear helmet. Why did they eventually talk about that? Because wearing a turban is a custom. Now, there are various customs all across India. A second custom, the Kugi people, Kugs, they have to have a knife. They carry a knife and some of them even carry gun. But in India, do you own a gun? Right? Your parents own a gun, or you know own a gun? The answer is no. So what happened was, for their custom, it is customary to hold a knife, and during election times alone, they'll have to go and give in their knives and guns to the nearest police station. And after elections is over, they're allowed to take it back. Okay. Why? Because it was their custom. Now, take for example our personal laws also. What religion part of? All of your life. So in Hindu custom, we have, some of us, we have the custom of walking around the fire. For some people, to get married, you have to walk around the fire, or even putting the sindoor, uh, the girl's forehead amounts to marriage. In other customs, it's like simply by putting that sindoor alone is more than enough to get them married. Never know where these customs come from. Some people will have the custom that, oh, I will give my daughter only to these castes. That is also customary. So, what is this custom? Basically, some kind of practice. Practice that has been followed by people for so long. It's almost as if it's a law. Now, take for example on, say, Pongal. If one office also was working, I think anybody will go and attend office. No, because it's like Pongal is a holiday. Forget the fact it's a national holiday, but here it is customary for us to go and have our rituals, our processes, whatever it is, because it's a custom. It's not law, but we'll follow it. That is only custom. And our laws recognize. Now, if you notice some customs, it's been converted into law. What has been converted into law is marriage, when in relating to divorce, inheritance, and guardianship. There's a lot of things that have been converted into a law. Then if you see, murdering another person is bad. Where did that law come from? It came from a custom only. At some point they decided that if you kill another person, it's bad. And then eventually the world itself came to that conclusion, and they said that if you murder another person, it's bad. And they made a law out of it. So eventually it all came from customs. If you even look at our Indian Contract Act, law, all of these come from business customs. So what has been converted into law has been converted. But there'll be some customs which are just followed as it. So even if you go before the court and you customary for us to do this, court will take that into they will take that into consideration. In your textbook, there is a classification of customs convention. I'm not going to go into all of that. That is purely from an exam point of view. So when we're going through the textbook once, I'll do it with y'all. But otherwise, the concept of customs is this. And the last primary in law is personal. Now, this is a very interesting topic. Actually, it's a very confusing topic, even for us law. Yeah, I'm a lawyer, but even when you're studying law, you'll realize personal laws are very confusing. What are they? They are laws by legislation, but they relate to, say, Hindus and Christians. Based on what? Relating to marriage, divorce, guardianship, a few topics. So, what are these personal laws? They are laws only, but then they apply to us based on our religion. Now, all of us are Hindus, so it's okay. But let's say there was if there was a Christian person here, they'll itself know that different laws apply. But with regards to what? Only with regards to the marriage, divorce, guardianship, inheritance, settlement. These topics only, we have different. Now, let's say our criminal law says that murder is punishable by law. Like, if a Muslim murders someone, does it mean that a different law applies to him? The answer is no. Why? Because we're only talking with regards to these. So, if say a Muslim person is marrying another Muslim person, one law will apply to them. Christians the same. Under Hindus, for the purpose of law alone, they've said all the Sikh, this Parsi, basically anyone who's not a Muslim or a Christian, considered a Hindu for the purpose of. Why? So that under these topics, you can have one law that is applicable to everyone. This is only personal. At the end of the day, these laws are also made by Parliament. Only thing is, they apply to you on the basis of your religion when it comes to these. So if you see Muslims, they have they follow their own, they follow the Quran main, and then like various other texts underneath. We'll go through the textbook with regards to what's what. Christians also don't believe in the concept of divorce, but they have marriage, inheritance. So there will be different laws that are applicable. Are personal. So we've essentially covered what are the different types of covered these statutes, precedents, customs, and person. This one, just we'll do one quick. Statutes and legislation is basically known as law made by legislation. There's a differentiation of jus scriptum, jus scriptum. In law, under law, law made by Parliament, custom. Now, this jus scriptum is divided further into supreme legislation and delegated legislation. What is supreme legislation? If that authority gets its power directly from a president, vice president, or all of them get their power directly. So therefore, any law made by them is supreme. Delegated legislation is the act of delegating the power to someone else, someone who does not have the authority. So if someone does not get its power directly from the constitution, known as delegated legislation. We'll do examples. Next one is precedent. Judicial precedents, we'll just study the different types. We have original, declaratory, absolute authoritative, and original means when a court gives a new interpretation. Declaratory, it's merely declaring an older settled position. Persuasive is precedent is not binding and merely has persuasive value. Two scenarios. One high court's decision is merely persuasive on another high court. Second, obiter dicta. The personal opinion of the judge simply has a persuasive value. Okay, absolutely authoritative is a higher court when they give decision compulsorily binding on, unless there's an error or mistake in law. In that case, the lower court can follow it. Then we have the doctrine of stare decisis. Do not unsettle matters that have already been. This is to bring about uniform law. Then under that we have ratio decidendi. Ratio decidendi is what the judge gives as a result of facts, arguments, evidence, etc. And then they give a decision based on merit. That will be taken forward as a precedent. Whereas obiter dicta is merely the judge, and it only has persuasive value and is not considered. And then we have custom and personal. Customs are it is any kind of practice that has been followed by a group of people for as long as they can remember. We'll do the criteria when I'm. And personal laws are also forms of law only, but it's applicable on the basis of your and with regards to marriage, divorce, guardianship, settlement. Now, moving on to I'll explain this concept for now. This one, I want you all to go back and read it in the textbook. I'll be continuing from this topic in the class, but I want you all to read it. So let's come to this justice equity. Now, before I move on to that, you all must understand one simple concept. First, check if there is primary source. Only if there is no primary source or you the secondary. Means first you check for whether there's a statute. Then you check whether there's a precedent. Check if there's a custom. Okay? And if personal laws apply to you, then check for that also. If none of these apply, none of these are there even, then you can apply justice. I'll give you an example. We have take cryptocurrency. I just said no law for it. So, is there a law? Now we have to try searching if there's any judicial precedent. Have any courts given any kind of currency? Let's assume that there is nothing. Customs. Did crypto exist longer than 7 years? Answers. So we literally don't have any customs based on it also. And obviously personal laws don't apply. So now if some matter comes before the judge, what do they do? No law, there's no precedent, no custom. So they will use their common sense. Common sense, another name is justice. If this, then obviously there's something known as sources of English law, which I want you to read and I'll explain. This justice, equity, and good conscience is literally the judge has some knowledge. He didn't become a judge simply by, I don't know, college graduate. He's had 10 years of experience. Through those 10 years, he's come in contact with so it's assumed that he will have the best knowledge to deal with any matter before. So he can use his like common sense, his sense of justice. There's a concept known as equity, what he believes to be, which he can apply in this. So in future, nobody can come and say, how did the judge give a decision? There's no law based on this matter. There's no precedent on this matter. How can this judge give? There's no such bar like that. The court can still hear the matter and still give a decision. And then mostly like the decisions will involve detailed guidelines as to what to follow, how to implement. Things like that will come up before. So that is justice. Good conduct. We'll just move on to the textbook where I'll show what. Where we started so and they started out with customs itself. If you notice, they've done this classification of customs. Again, I'm not going to do it with you all now. In my notes, that you all can remember. And this topic is purely for the purpose of studying for it. There's no like, honestly, I've never come across this classification until I read this book. So we'll leave it for now. This 8 points is very, very important. There in your textbook, so mark it as important. They've asked this question, they will ask it again. So if they feel like. What are these 8 points? For a custom to be valid, it must be immemorial. That means for as long as we can remember, it must have been practiced. It must be certain. That means one person can't say, no, you should walk 3 rounds around the fire Another person should not say, oh no, you should actually walk 7 rounds around. It must be a standard decision. 7 rounds only. Reasonable. So let's say, as example, my community has a custom of stealing things from. Do you think it's a valid custom? Possibly not. One, it's not reasonable and it's not conforming with law. So the custom must not be against law also. So the custom can't say, oh, we murder people who run away from. That is not allowed because murder is not allowed by. And it must be reasonable also. So, like right now, if I tell you all, okay, you'll have to finish reading that full textbook in the next. Is it possible? All right. So customs must be reasonable also. Then compulsory observance. This is very, very important. We can't choose to not follow a custom for say 10 years and then after 10 years, one community is following it. That is not a valid custom. It must be observed by everyone in that community. Then unanimity of opinion. This is the same as certainty. It's like saying everyone must know that, okay, yeah, if I walk 7 rounds only, I'm married. Anything less is not allowed, anything more is not counted. So this is unanimity of opinion. Peaceable enjoyment means without harming another person, you can follow whatever. And consistency and reasonableness, compulsory observance all mean this. But essentially, these 8 points you all must remember if they ask this. In customs, they can ask only 2 questions. One is, what are the requisites of valid custom? Second one is classification. That's all they can ask. Next one is judicial precedent. So this precedent only they will talk about. Yeah, so they go into a little bit of detail telling you about the High Court, and then they come down to types of precedent. You have your 5 types. Again, first chapter, follow my notes. This is still confusing, some words you may not understand. Then after that, doctrine of stare decisis. Adhere to the decision and do not answer or establish. Then they go ahead to give what is res precedendi and what is ob. Read it, you'll understand great, but follow my notes. Then they go ahead to in statutes and legislation. They make the distinction between jus scriptum, jus non. Then they say what is supreme or delegated. That is personal laws. The first bit is with regards to what is personal law for Hindu. So we follow the Shruti, Vedas, the Muslims follow the Quran and digest. These are just terms that it's best you all remember. Now, the secondary source of Indian law only is justice equations. I will explain this concept a little once we do some more chapters. It won't make sense. So, otherwise, it's simply the common sense. The sources of English law only. I want you all to do a reading. See what you all understand out of it, and then I'll start from this. Now, if you notice this, in sources of English law, you have common law. Then you have law of merchant, principle of equity, and statute. You notice these 4 concepts are very similar to what I've already taught you all in primary. But read it and tell me if you all understand anything and if you all don't understand. I want you all to read sources of Indian mercantile. I want you all to read. It's actually easy to understand, but I want to know how much you all understand. So tomorrow's class I'll be starting from that topic, and then I'll finally move into what is this, the 5 schools. Question? That's not. Okay, so I'll see you guys tomorrow then. There is one. For all the other chapters, immediate. Why is because I need use to textbook.